Thank you so much for joining us today. We're joined here by an amazing group of experts. Cynthia Smith, who's at Humentum, will be moderating the conversation, and then we're joined also by Shannon Meehan and Sabrina Segal. My name is Jenna Thoritz, and I'm a senior program manager here at Humentum. Just before we dive into the conversation, a little bit of housekeeping. Please feel free to turn your videos on so we can see your faces. And please make use of the chat if you have questions throughout. We'll be taking note of questions throughout and certainly leave time for a dedicated Q&A at the end. I'll be popping in some resources from Humentum in the chat as well. We've been churning out and curating a lot of resources to help everybody in this time. And then also, if you are a Humentum member, please join us on our networking platform, Humentum Connect, where we're posting updates as things happen. So really happy to be here with everybody, and I'll turn it over to Cynthia.
Thanks. Thanks so much, Jenna. Really appreciate it, and welcome everyone. So happy to have you join us today. As some of you know, we've been trying to at Humentum, we do try to do two things with the sector. We try to accompany you and make some sense, engage in some sense making of what's going on in the ecosystem, the development and humanitarian assistance ecosystem, and help make sense of it as it occurs, and then also do some futures thinking of what comes next, and how can we all work collectively to help shape it. I'm joined today, I'm really thrilled by two of our industry's experts, and really looking forward to diving into a conversation more about the legal goings on right now that are impacting particularly U.S. Government foreign assistance, and also kind of what next steps, what are the actions that implementing partners in particular can be taking in light of what has taken place over the last month. First, I'm joined by Shannon Meehan, who is an associate consultant with Humentum, has been for many, many years. She has over 30 years experience in the industry. She's done everything from managed country offices and programs across the globe, to advocacy, to Peace Corps work, and for over a decade and a half now has been a consultant on all things kind of compliance and U.S. government compliance specifically. I'm also joined by Sabrina Segal, who is the director of the Risk Collaborative, which is a nonprofit. She's a lawyer, and she has decades of experience in the industry, working in the capacity of a legal and ethics advisor, procurement officer. She's worked with USAID, and she's run country offices and for a variety of organizations and implementing partners. So I am just real thrilled to have both of them here today to engage in a conversation, and then we will hear from them, and they can kind of set the table for us, and then we're going to open it up for questions and comments from everyone else. So really encourage you all to actively participate both in the chat as well as just raising your hand and sharing. So I'm going to get us started with Sabrina, I think. Welcome, Sabrina. Really happy to have you here with us at Humentum. Can you tell us a little bit, I don't know if that's possible, but can you talk, please, about where we are today? It's been a whirlwind of a month and a half, or I think it's been a month and a half, and that might be an understatement for many. We've seen a lot of executive actions from the new administration. We've seen a number of court cases in response to those, many of which have direct or indirect bearing on the work that implementing partners across the sector do on a day-to-day basis across the globe. So I'm going to turn it over to you to set the table for us. And welcome again.
So you give me the easiest question. Cover everything that's been going on for the past week. Well, first of all, thank you so much to the team at Humentum and to everybody who's joining on the webinar today. I will do my best to provide a plain English interpretation of everything that's been going on at the various levels of the judicial system. And it was funny when I posted about me being on this webinar and talking about the cases, I said that, I'll try and provide an entertaining interpretation without my emojis. And somebody said, but we like your emojis. And so I said, okay, I've got my orange clowns here. So if you guys who follow me on LinkedIn know who the orange clowns are. And so, in case we need them later, they're here. So where do we begin? Well, we begin on the 20th of January when a whirlwind of executive orders were signed by the current president. And one of those executive orders was immediately freezing all foreign assistance funding. That initially people sort of just approached that executive order with deer in headlights, being, what do you mean freezing all foreign assistance funding? And this administration was not here to play. They knew exactly what they wanted to do from day one, and they went about doing it. And their goal was really to dismantle the U.S. Agency for International Development and to shut down, essentially turn off the funding for anything that was going overseas that did not, in their claim, make America stronger, better, faster, whatever, younger, give us better skin, whatever they're claiming at this point. So the funding freeze case, initially there were two cases. There was a case having to do with the funding freeze, and then there was a case having to do with the immediate freeze of, sorry, excuse me, my 4-year-old is talking to me. There was a case about staffing, and the staffing case has since been, in theory, resolved. We all know that the judge in that case ordered that the staffing activities could move forward. All of you have seen the really heartbreaking images of what we saw outside of the Reagan building on Thursday and Friday of last week. I am actually located in Kigali, Rwanda. That's my background, and have a lot of colleagues and friends who were not only in the mission here, but in the mission that were evacuated in DRC, as well as missions all over the world. And I've been in touch with them, and just the stories that you hear are, as we all know, really heartbreaking. The Foreign Service Union has not, at least to my knowledge, appealed that decision yet. There is a window in theory for them to appeal that particular decision. That decision was made on the concept of being able to show irreparable harm. And the judge in that case basically said people being out of a job and having a financial loss doesn't necessarily rise to the level of irreparable harm. However, if there were incidents of physical safety and security or other elements having to do with that staffing termination, the court would hear those claims. So I haven't seen anything coming out of that yet. We are still tracking it in the sense that, trying to bring 7,000 Foreign Service members with their families back to the United States with a logistic staff of something around 230 is challenging. Trust me, I remember my colleagues, I was in the counsel's office there, the RLAs moving around, and you had maybe had a handful of them every summer, and the logistics was a disaster. So I can't imagine everybody moving back. So that's one of the cases right now that's fairly calm because it seems to have been decided, but that one could come back up with other claims. The funding freeze one is the one that everybody is still feeling right now. And that case is proceeding in two ways. The case with the district court in DC is still proceeding on the merits. So the judge there is receiving briefs and arguments from both parties about whether or not to order a preliminary injunction. Right now, that case is functioning under a temporary restraining order. A temporary restraining order is exactly what it sounds like. It is temporary. Typically, a judge will order a temporary restraining order when there is a fast-moving situation, and it's possible that you could have parties that could face irreparable harm if that decision or action is allowed to continue. The judge in this case heard arguments on both sides and decided that a TRO was appropriate in order to turn the funding back on and essentially pay for anything that was incurred prior to the funding freeze order. Now, we have ended up at the Supreme Court, which I'm sure a lot of you are following that, because the government, these guys, have decided that Judge Ali in the district court was being a big old meanie for telling them that they needed to actually pay their bills. They had 2.5 weeks to get the funding moving again. not necessarily to fund anything new or things moving out into the future, but simply paying the bills that had been incurred and had been sitting there on the docket. The government did everything but turn the money back on and pay its bills. They continued to try and fire people. They claimed that they were doing reviews of the agreements. They were coming up with listening sessions, and they were doing everything but paying for the things that they needed to pay for. The claim that they came back with the most was, well, we're looking for fraud. Well, we know, how that goes. So what happened was, on the fourth enforcement of the temporary restraining order, the district judge essentially said, look, I'm tired of you dragging your feet. You now have until 11:59 on, what day was it? It was a few days ago, in order to get this done. It essentially gave the government about 30 hours to get their act together and start to pay things. The government then threw up their hands and said, they pulled a Darvo, right? Where they flipped everything around and they started blaming the judge for the fact that they weren't engaging and doing what they needed to do, and saying, we can't possibly do this in 30 hours. You're being really mean to us. This is unfair. And they appealed. They appealed to the Fourth Circuit. But before the Fourth Circuit even had a chance to respond to their appeal, they applied at the Supreme Court. What they are filing on very specifically is Judge Ali's fourth enforcement of the temporary restraining order, ordering them to start to pay things within that 30-hour window. What is interesting here is that the government still actually has not appealed the original temporary restraining order itself. So there's a lot of conversations in these legal filings about whether or not this is the proper process and whether or not they can even appeal something that they didn't actually appeal the original underlying TRO. So that's very legal and technical. We won't go down that road. There is an interesting case that I was asked about today on LinkedIn. There's an interesting angle of the argument where the government is now saying, well, we just finished our massive review of foreign assistance. And as you all know, 10,000 agreements were all terminated and canceled. So we just finished this review. We're keeping this small fraction. Everyone else is terminated. Therefore, the funding freeze itself no longer exists. And therefore, this whole claim is now moot, right? So in the courts, moot basically just means there's really nothing left to argue about. Why are you arguing about a funding freeze? It doesn't exist anymore. There is a broader issue around this. The government is also arguing that the plaintiffs shouldn't be bringing these cases in the district court anyway. There's this thing called the Tucker Act in the Court of Federal Claims. They're saying that these things should go over there. In reality, what the plaintiffs were arguing was, number one, we need to get paid, but number two, your decision to freeze all federal funding in the way that it was done under the Administrative Procedures Act was, and you've probably heard this phrase, arbitrary and capricious. It basically means that the government was just sort of doing something very flippantly. And we, as citizens, if we're affected by that, have the ability to bring that to court and say, hey, government, you didn't put thought into this. You weren't doing this in a well-structured way. And so really the APA claim is the underlying claim, along with the, we also need to get paid, you need to pay your bills. So what the Supreme Court is specifically looking at is whether or not Judge Ali's fourth enforcement of the temporary restraining order, giving him that 30-hour window, was okay. What it will be very interesting to see if the Supreme Court does is opines any further outside of that technical request. The filings also contain a lot of information about separation of powers, Article 2 arguments about how Congress and the executive branch are supposed to be working together or not. What can the president do versus what power has Congress retained? And it will be interesting to see if the Supremes decide to opine or give any hints or breadcrumbs about how they feel about that particular matter. So we're watching that one from the Supreme Court side on that very technical procedural element. Again, the funding freeze case is proceeding in the district court. They are receiving briefs on whether or not a preliminary injunction, which would essentially be a longer hold on the funding freeze, if the judge will rule on that. It is looking promising that there likely will be a preliminary injunction, but a lot of it may depend on what the Supreme say out of that SCOTUS case. A few other cases that I want to just, sorry, Cynthia.
No, that's okay. No, I before you dive into the other cases, just tell me, I want to check my facts here. So in terms of the Supreme Court, they have all the briefs, including the reply from the government in response to the plaintiff's response to their initial request for review by the court. So that is any day now, right? There's no kind of timeline. We just don't know when. Yeah, exactly. Someone just asked, what's the expected timeline? So we don't really know. It's a waiting game, but it's been moving fairly quickly. So we'll see. In the meantime, the underlying case, am I correct that the hearing, I think, is on the 6th, right? 2 days from now on the injunction itself, on the merits?
Correct. So what is interesting about the SCOTUS decision and the district court decision is that originally the district court was scheduled to have a hearing on the merits for the preliminary injunction today. It was moved to the 6th, and no one sort of knows why. Maybe it was because of just the volume of the briefings that were delivered and the, sort of additional statements that were provided, all the things that we've seen floating around lately, have been provided. It could be that the judge and the courts basically just said, we need more time to digest all of this. There is a theory that, somebody from SCOTUS picked up the phone and just said to the district court, we're going to do something on or about this date. And so that could be the reason why it was moved to the 6th, but we don't really know.
Sure. No, thank you for that. I think it's important to just be mindful of the timing. And in the meantime, I will say, you mentioned, as many of you know, we have been tracking kind of the impact of the stop work orders, the suspension of work orders, as well as the terminations now, the kind of onslaught of 10,000 plus terminations that have been sent out to implementing partners. And all the confusion that entails on a weekly basis. We, together with Accountability Lab, have been tracking and conducting a survey online, and Jenna can put in the links here in the chat, information about that with very current data on how it's impacting you all. I know each organization individually knows the impact in terms of layoffs and staffing and operations, but our Global Aid Freeze Tracker really does kind of paint a more omnibus picture, if you will, of how it's impacting organizations large and small across the sector, and it is dire. So I know we're anxious to get into to hear what Shannon Meehan has to say in terms of what are some things that the organization should be doing right now in light of all this. But before we dive into that, I do want to give you a chance, Sabrina, to give us a little bit more information on some other kind of tangential cases. Yeah. And then
really quickly, I promise. And then Shannon, absolutely, the floor is over to you. I do want to answer though. James asked a question in the chat about if there's a preliminary injunction, do you anticipate in order to avoid the 10,000 terminations? What type of timeline might we expect for appeals and final resolution? Okay. The first question is the preliminary injunction, again, would be specifically around funding freeze. The recent 10,000 terminations, I am predicting is going to be a separate filing, again, under the Administrative Procedures Act. Now, they may try and bring that in because it's a related claim to what's been happening. They're claiming that they reviewed all of these agreements and they terminated 10,000 of them as part of the funding freeze, pencils down, if you remember that phrase that came up during all of this. And so they may also try and add that claim, or it may be a separate claim. But the preliminary injunction itself, unless an additional claim is brought in, would not trigger a voiding of those terminations. So I hope that answers your question, James. The timeline, justice is slow. They're moving, honestly, they're moving as fast as I've ever seen a court move on this. They're getting a lot of attention. But the other thing too is we want to make sure that the judges do take the time to educate themselves on this, because there are some very, very tricky contracting, grant agreement, bodies of law that are around this, along with, not to mention, the constitutional elements that we're talking about. So this is a very complex claim. The only other three cases that I want to mention really quickly is the DEI case that we saw that was in Baltimore, where the judge there froze, did a preliminary injunction for any of the DEI activities and said, knock it off. This also will impact the funding freeze arguments, because DEI was at one point one of the reasons why they were arguing that they were freezing some of the funding. We saw all of those ridiculous articles about, LGBT operas in Ireland and, all of that stuff. So, the good news is that's been frozen. So that line of argument is a bit reduced for these guys. The OMB domestic charity or domestic funding freeze has also been temporarily restrained and paused. That's good for domestic charities. And related to that is the refugee resettlement decision that has also been paused. And the last time I checked, that was about $36 million for refugee resettlement with about 10 organizations in the United States. Again, this isn't directly related to the foreign assistance freeze, but I do know that there are a lot of networks where hand in hand they work together, both internationally and domestically. All of these things are good for the short term. It is showing that the plaintiffs have valid claims that have merit. The question is going to be, how quickly can the judicial system analyze and start to make decisions on this, because we know that all of their organizations do not have deep reserves. And part of the strategy, I hate to say it, for the government right now may simply be that waiting game, because they know they can outlast anybody else. So I do have some suggestions for organizations to how to get through this, but let me hand over to Shannon right now, and I've talked enough for now.
No, that's been fantastic. Thank you so much for that thorough overview. And I do want to let you answer one question, and maybe it's one that Shannon could also answer, but I see in the chat that, we're still getting DEI certification requests. Is that allowed in light of what you spoke about the DEI case?
I mean, allowed. What is allowed these days? I guess I would need to know exactly DEI certification requests. Is this from the government saying, are you still doing DEI stuff? Like, tell us whether or not you're doing it, or honestly, the advice that I have been seeing and giving people is to acknowledge that request. And, if you're feeling froggy, you can come back and say, but we also understand that, and I can put the citation in there that says, who exactly put who put a pause on this. And so therefore we acknowledge your request. However, we're not going to respond to it at this time, if you're feeling like you have the courage to do that. Otherwise, honestly, you'd really need to get guidance from your own leadership and trustees and lawyers to tell you whether or not technically they really shouldn't be asking for that, but we know that there's lots of things that they shouldn't be doing technically anyway that they continue to do.
Thank you. I see there's a clarification, but let's hand it over to Shannon now, and then we'll get into some of these questions in more detail. Thank you so much, Sabrina. So Shannon, what has all this meant for our implementing partners across the sector who get USG funding? What are you seeing in your day-to-day work with them? And then also, what should they be doing? What should they be doing if they've gotten a termination notice? I even see in the chat people who, and I've heard about people getting a termination notice and then, being told that's actually not accurate. And then, things suspended, but then unsuspended and then waived, but still terminated. So it's a bit of a chaotic mess out there. So why don't you tell us what what folks should be thinking about, what they should be doing, some top line tips, please. Thank you.
Okay. So that's a really good description. It is, I've seen it all. I've seen suspended, terminated, rejuvenated, and it's like, the number one problem is the lack of accurate information to the implementing partners. They get a letter, you're suspended, and then they get a letter saying, and instructions will follow. But then they annihilated they took out all the employees of AID that would have been able to give them instructions. And then there were no concrete instructions. That's one of the major things. And now with the more than 10,000 terminations, it's the same thing. They've received a letter that it's terminated without any detailed instructions about, so what's going to be allowable and what's not going to be allowable, etc. So in working with the clients that I work with through this interesting time that affects so many of us, right? And all of us on this call, So number one is document everything, every decision, every cost that you make, not just have the invoice, have the memo to file with that invoice. This is why this cost was occurred because of the suspension or because of the termination. Therefore, this is justified. And then in regards to, I've put in the chat, your best friend from the regulation point of view, if you are working on grants or cooperative agreements, is 2 CFR 200, 340 to 345, and the cost principle 2 CFR 200.472, which explicitly tells you exactly which costs are allowable and unallowable in termination mode. So I anchor myself when I talk to my clients. I'm constantly cutting and pasting sections 340 to 345 and the cost principle of 472. It's something that you can focus on and anchor your decisions that you are making. So the regulations are still going to be your best friend. One, because OMB created these. So if the director of OMB, which has a lot of power in this situation of ending funding, they're going to be anchored in their own regs. I really hope anyway. And it's the way you can. So anchor yourself in the regulations. The other thing that people don't realize is in the response of the US government, they said, we were allowed to terminate because of the clause in your award. However, that statement started in 2022. In 2022, 2 CFR 200 added that paragraph under termination in section 340, and as per the term and condition in your award. Many of you may have awards prior to 2022 that are still in play that do not have the termination clause in it, and therefore they are not responding according to any term and condition of your award. Yay, ding, 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 ding. So make sure that you have scoured your award, because one of your defenses is this termination clause does not exist in our award, and therefore this is not terminated, or however you want to take that. But it's important to read your award. You have to anchor yourselves in the information that is available and real to you. The other thing is to read Marco Rubio's letter waiver of what he's willing to provide waivers for. And if you can make the case that what you do sustains and saves lives, you may be able to convince to get that waiver. And it's not just humanitarian work that saves and sustains lives. Most of my work has been in humanitarian, but I've also done long-term development. And many of you, your direct impact is saving lives. And when it's removed, you can make a direct link that people will die. And I think if you show that and you advocate, and this is your senior leaders and your board members that have all those lovely political connections, literally making that case in front of Rubio. I would bypass Morocco and try to go straight to Rubio. Morocco is not, in my opinion, our friend. And FYI, his wife advises the president on foreign assistance. So there's also a conflict of interest. I don't know if anyone knew that, but his wife is the direct appointee of, what's your emojis? Show up the emojis, Sabrina, of the president on all things foreign assistance. And Morocco is the assistant administrator of AID. Do the math. So my top 3 things of advice are: 1, read your award, follow the regs, justify everything according to the regulations to your award, and lump your costs. You either, this cost is required by national law in the country where we are operating. We can't get around this. I have to pay severance. I have to pay out all vacations. I can't get around this, or I'll be legally fined even more money. Number two, this cost exists because of suspension or termination, or this cost was planned because possibly you would have resuscitated our project, and ending this lease would have cost more than sustaining that cost. So those are very important ways in which to justify your costs. Number two is advocate. If you can make a link to any of those topics in the waiver, make the case. Prepare for the worst, hope for the best. That's what I usually do. And advocate. The other thing is, many of you have been asking me about appealing the termination decision. You have to wait. You have 30 days from the notice of termination, according to the regulations, to send the appeal. The appeal, I don't know who that would go to, actually. It's hard to target. It's supposed to go to the assistant administrator, which currently is only really Peter Morocco. So you know what you're up against. But if you can make the clear case, and in all cases, I would CC your original donor agency. Like if it's PRM, I would CC the people that you know at PRM, and I would CC Marco Rubio, the Secretary of State, and saying, I'm appealing this decision and here's why. And we actually have a case to be part of the waiver. Life-saving, life-sustaining without this. And security issues, that's the other thing. There's a lot of ways in which what you do, if without it, our security of our nation is less. Like you have to find the ways in which, sadly, it fits within their arguments. But you have to be very careful with your appeals that it's worth the time and effort. Because it costs money to do that, to make an appeal. It's a lot of labor, it's a lot of documentation, it's a lot of making the case. You've got to make the argument. And these are not easy people to sway, in my opinion.
So Shannon, thank you. I don't want to stop your role, because I think
It's okay.
I need more tips for folks. But to your point, like the cost benefit analysis, right? I mean, I know a number of organizations, some are small, some are very large. Irrespective, they've all been hit financially in sometimes insurmountable ways. If you've received a termination notice, or even if you haven't, and your organization is undergoing financial constraints and having to lay people off, do you have the option to request a termination? How does that play into all of this? And
Self-termination?
Yeah, self-termination. And what would you suggest in terms of moving forward with that in the event that an organization feels like it's in their best interest to do that?
Yeah, it's not unusual to self-terminate. Many of your organizations did this in 2003 when the United States invaded Iraq. And you're like, we can't have US government funding in the Middle East while G.W. Bush and et cetera invades Iraq. So self-termination is you make the case, here's what we're doing. We understand the shift in policy priority. We're no longer able to satisfy X, Y, and Z, or you can state your ethical and philosophical reasons, and you wish to terminate the award. And then by doing that, you would submit in the next 30 days, we will be able to terminate, and we will submit a final financial report. And we estimate roughly this amount of money will be owed to us based upon a rapid termination of this project in the next 30 days. So you are allowed to self-terminate, and some are actually upset that the terminations came last week because they were trying to go through that process, and now they're receiving the terminations. So they're more worried about getting reimbursed for their costs. But again, the cost principle 472, 2 CFR 200, 472, it's literally a checklist of everything that you are allowed to charge to the US government under termination. So don't neglect going through the details of that cost principle. And then again, have a memo to every single expense that justifies why this cost must be reimbursed. You have to follow national labor, etc. The fourth thing that I would recommend is everyone needs to pivot to new donors, different funding. And I would lean on foundations, because if many of you are looking globally, the Dutch government just reduced their efforts on international funding. They took out their DEI. They want it to be anti-immigration. They want it to be pro-trade of Dutch companies. So very Trump-like, but in that lovely European, but we're still riding the line of human rights. The UK government went from 5% GDP down to 3% GDP in the last 10 days, and they're shifting things to defense.
Yeah, we're definitely seeing this across a number of bilateral agreements, and it's not just because of, I think probably the U.S. government is probably the most overt, obvious, I guess egregious is a fair word, case, but many other countries are also kind of constricting and reducing funding that used to go to ODA to defense. But taking us back to some of the questions, I do see, sorry, Jenna, I lost the chat for some reason, but
I can read out one of the questions that I'm seeing.
thank you.
Yeah, I have one question from Lawrence on what is the implication of agency foreign assistance review data call issued on February 26, 2025 on grants and contracts already terminated.
And that's for you, Sabrina or Shannon, either or both who want to respond.
So the budget review, so they finally, in my opinion, the federal government woke up and realized that USAID and the State Department are not the only agencies that have foreign assistance dollars. You have the United States Department of Agriculture, Justice, Treasury, Labor, almost every, HHS, CDC. I mean, it's massive. So almost every U.S. government department, which for some of you, we call our ministries departments, there are 15 departments. Almost all of them have some type of foreign assistance. And so now the Office of Management and Budget sent out a memo instructing all other departments and agencies to do a full review and to determine by April, I think it's April 20th, whether to keep or terminate. So it's now across officially the board of all U.S. government funding, because I was secretly going, yay, they haven't figured out yet that so many other departments give foreign aid. Many of you, some of you who work with child labor, you probably have Department of Labor funds. Many of you have USDA. What I don't understand is if the Department of Defense is exempt. That seems to not be the case. I think even the Department of Defense has to analyze all of their foreign aid that's, quote, non-military like. So
Sabrina,
it doesn't affect state projects. No, it's exclusive of the Department of State and USAID. It's for all other departments to fall in line with what they did with the State Department and USAID. But Sabrina might want to add something.
Yeah, no, I think Shannon, that's the perfect summary of what that document is. I do know, it's funny, because my partner also works in this space, and as soon as that foreign assistance fund freeze memo was signed on the 20th of January, I remember turning to him and going, I wonder what the agriculture lobby is going to feel about this, right? Because having worked at USAID, like the biggest domestic constituency that foreign assistance has is farmers. That is the biggest domestic constituency. It took them about 2 weeks to wake up and be like, wait a minute, this is going to affect us. And that's then when you saw things like the McGovern-Dole funding for food for education, things like that. Those wheels started grinding again, because the ag lobby was like, we're not going to do this. But you've seen a lot of the reports lately about, the Plumpy Sub. There was the factory in Georgia and the factory in Rhode Island who are buying soy and peanuts and whey protein and things like that, all from domestic farmers. And now They can't deliver their product. They can't do anything because of this insanity. So, I mean, I think, yeah, to go back to the data call, that's exactly what's happening is they're trying to now actually say, wait a minute, we know that there's other things happening in other places. And what we hope is that some of these other agencies have domestic constituencies, which can now speak up on behalf of whatever these programs are to try and at least retain a minimal amount of them. I want to go back to Shannon to what you were talking about with the waiver process. So I posted today on LinkedIn with my analysis the full Nicholas Enrich memo, the acting administrator for global health, that had been sort of floating around. You saw like one page here and there on like Twitter and things like that. But the full memo, since it's been filed as evidence in part of one of the cases, I was able to post it today. So you can find the whole thing. And honestly, it's a very interesting analysis day by day from the 28th of January through the 28th of February. So a month of what happened. And basically all of those claims around, well, you can get a waiver for this and a waiver for that. Like no one has gotten a waiver. Like, I mean, there may be, a few, sparkly unicorns somewhere that got a waiver, but no one that I've seen has gotten a waiver. And even when you're making those arguments about national security and making America great again and all of that, this waiver process that they keep talking about, honestly, is a red herring, I think. And it comes back to the argument about intent and looking at what the government is arguing, and then also what other organizations are saying. And I posted, I think yesterday or the day before, about the concept of pretext. And this is going to be a big thing that the judges are going to be looking at, because when you're talking about pretext, essentially what you're saying is that the government is doing one thing, or saying they're doing one thing, but in reality they're doing something else, or they're doing it for different reasons. There is this concept of goodwill, and I forget exactly what it's called when you're talking about the government, but there's this concept within case law that the government, unless it is shown to not be acting in goodwill or in good faith, there is this assumption, there's this presumption that we give the government that they are acting in good faith, they are acting with goodwill. But that presumption is not non-rebuttable. You can rebut it. And I believe that looking at Elrich's memo, looking at the evidence that we have from all the Jane and John Does, where we have all of the affidavits that are being filed about how people were being treated when they were being evacuated from DRC, about how there's been no responses when small organizations are trying to reach out to their agreement officers or their contract officers, that what I've said a lot is the cruelty is a feature, not a bug, in what's happening right now. And and I think that pretext argument is going to be a powerful one for the plaintiffs. And I also think that the judges, at least the judges that are being honest, are going to see that the government's not really engaging in good faith with goodwill. And therefore, I'm not sure if that waiver element, will be something that is an option. I hope it is, but I'm not sure it will be. The advice that I've been giving organizations is, honestly, do what you need to do to survive for the next 18 to 24 months. And if that means you need to go into hibernation, it is heartbreaking, but you need to survive so that when these claims, when these payment claims actually start moving, which is not going to be for at least 18 to 24 months, you are still an entity there to receive those funds and then do what you need to do with them. But again, I've seen a lot of organizations furloughing people, a lot of organizations really downsizing. If you decide to go into receivership or bankruptcy or any of that, that will then really limit your ability to make some of these claims, because there is no entity left to receive them. So if you can go into hibernation, and then we see what the midterm elections look like, we see, what Congress looks like, and then we see if we can start to come back from some of this chaos.
Thank you for that. I'm gonna take us, so trying to get the forest for the trees, and then get back into some of the macro, though. At the end of the day, organizations right now are making tough decisions, right? And I don't, I do know from our own polling and surveying that It's something like 50%, don't see beyond like three months of a runway. So it's a good portion of organizations don't have reserves and don't have the ability to sustain themselves over the long term. What would the two of you say to those who are holding out hope that something's going to change in the near term to change their fiscal realities vis-a-vis U.S. government funding that they have been administering until they got a suspension notice, a stop work notice, and or a termination notice? I'm not trying to be bleak, but I also just want to just level set and make sure, we're all operating from the playbook.
I mean, my initial reaction on the January 24th was pivot to other funds immediately. And your board needs to, if you have a type of board that has, fundraising responsibilities, they need to crank that up as much as possible. The other day, a health organization, I said, please go to the door of the Gates Foundation because, the billionaires have the money, and bang on their door and say, okay, Gates Foundation, now that the government has annihilated the antiretrovirals and HIV/AIDS, which is one of your pillars, here's my proposal, please fund me. Or like South Africa has been completely shut off from everything. So I think the immediate pivot to funding is critical, and reaching into the fundraising arm to try from your board and others. The other thing is, I definitely agree with Sabrina on, please don't, if at all possible, don't shut your doors, and have that alive, even if it means it's super much smaller than it's ever been, because you're right, then you will never see the money that you spent up until January 20th or 24th, which is another question mark that everyone's asking me. Will I be able to claim everything up through the 24th, not prior to the 24th? Because everyone received their suspension at the end of the day on Friday. This administration does things at midnight. So make your arguments, make your case for as much reimbursement as you can. But organizations need to have a very frank conversation with their board. And I think boards need to step up in their leadership of how passionate are they about these organizations, and how can they use their network for bridging a gap.
Sure.
But pivoting to different donors, like in the 2 webinar course that we're doing, in the second webinar, there's a whole section on going down the path of, there are so many, somebody needs to spend the time going down the rabbit hole in the internet. There are so many pockets of money that we don't realize are there and that you would qualify for, even if it's $50,000. We're now at a point of survival, and you need to possibly piece together 20 small grants that equal 500,000 to keep your doors open. I think that's the kind of reality that we're confronting.
Can I just say something quickly about trustees? Because I think, Shannon, you hit on a really excellent point there. One of the things that the Risk Collaborative that I run is focusing on is trying to get trustees in particular to have a more realistic view on risk, and empowering them with the vocabulary and the approaches and the skill sets that they need to support their organizations, particularly through crisis and things like this, but to also be able to, like you were saying with some of their fundraising roles, engage with funders in a conversation about risk sharing instead of risk transfer. And risk transfer a lot of times is what prevents these non-bilateral funders from engaging with smaller organizations, because they're like, oh, well, they can't pass our due diligence requirement, or, whatever. We need to now actually shift that conversation. And that's what we're talking about at the Risk Collaborative, as we talk about redesigning, rebuilding, and rebalancing the power around this. And right now is a critical moment for trustees to be engaging and thinking differently about the risk to their organization, because the table has absolutely turned. And now it's like, yeah, well, are you still going to be a going concern tomorrow? I don't know. But what we need to be doing right now is taking action. And taking action requires being comfortable with risk, with threats and opportunities. And it's really all just sort of coming together right now with the catalyst of what we're seeing going on with the government.
Absolutely. Yeah, no, this is an interesting time. It's a challenging time. It's an existential crisis for the sector, but it also presents an opportunity for kind of a reconfiguration, if you will, and hopefully in solidarity, organizations can come together internally with their trustees and their stakeholders, but also across the sector, you know, to kind of reshape it. In the immediate term, going back to that though, we have a lot of very specific questions that I'm just going to throw out there and let you all answer as they come. And the first that someone asked was, what was the exact date that the termination in 2 CFR 200 you don't know, came into
Now,
effect?
I don't know the exact date in 2022. I just know when it was slightly revised in 2022. But basically, if your award was signed in 2021, read or earlier, read very carefully, is there a termination clause or not? And if there isn't, that's like it's expressed in section 340 of 2 CFR 200, you have a lot more to push back with, because then they aren't actually their statement of following your award clause didn't exist, and it was never amended to the new regs, for example. But I don't have the exact date.
Can I ask
'Cause it was
Shannon a
one of those-
question?
Yeah,
Yes.
go ahead.
Yeah. So Shannon, I recall something, and so I'm not an expert on this area, but contracts were different than grants and cooperative agreements because a contract can be suspended, but grants and cooperative agreements could not. Is that correct? And if that is
No.
correct, no, that's not. Okay, they can be
No.
suspended?
Yes.
Okay, all right. Okay,
Grants
good.
and cooperative agreements are allowed to be suspended.
Okay.
That's always been the case. But federal acquisition regulations, remember, that's a procurement relationship, not an assistance investing in your mission. So the legal aspect, it's easier to argue a contract than a grant and cooperative agreement. You have more of the law behind you in a contract than you do under grants and cooperative agreements. I'm so sorry to say that.
Yeah, and
But
isn't
it's
it true
true.
that under contracts, with the stop work orders, in a contract, you have certain rights that you don't have as a grantee or a recipient of a cooperative agreement, right? So the suspension notice, there's just less opportunity to necessarily directly recover costs, whereas under acquisition rules, you are able to recover your costs technically, legally, according to
Yeah.
regs.
Yeah, because it's due to a government decision, and yeah.
Okay, well, thank you. Thank you for that. And we can look into that date, yeah? And get back to folks, in an email follow-up to this, webinar. So, another question. So 2508, doesn't affect state projects. They're wanting to know if the document, no, it does not.
We
Okay.
answered that earlier, but no, it doesn't affect the Department of State projects. That's already been in process. This was for all the other departments of the United States.
Another question is there a new process for requesting a payment now, or should we just wait for the PMS to start working?
So this is a hard question to answer that everybody is dying to know, because the payment system still isn't accessible to those of you that are part of the payment system that are able to draw down. They haven't opened that up. Although they could shut it down in 5 minutes, why they're saying that'll take a long time is beyond me. It's literally a flip of a switch. But secondly, many of you still in your country office, in your countries, the staff are, many national staff are still at USAID, and you're talking to those national USAID staff members or the expatriate AID members in your countries. Keep your lines of communication open with them to say, how do I submit for reimbursement? Because what they might do is say, none of you can draw down from the payment management system. You all have to submit for reimbursement. I don't know. They could do that, but we don't have the crystal ball of why they aren't opening that, even though they know, according to the terms and conditions of your award, if you have been terminated, there should be a deadline and a process to submit your final financial report. And then most of you have outstanding bills that need to be reimbursed. But I don't have a timeline as to when that's going to be opened. But if you have people at the AID office in country, keep talking to them. When can I submit for reimbursement?
Awesome. Thank you. Michael wants to know if you all have any thoughts on the executive order that directed the heads of agencies to scrutinize NGOs domestically. As he says, the tone was very dark. Are we seeing any immediate implications of this?
I can talk to this one a little bit. I mean, it was very dark, and it was something that I think a lot of civil society organizations were the ones who were paying attention were kind of prepared for. We kind of know that the tone and tenor of this administration coming in is not one that's super open to organizations that are going to challenge, speak up, speak out, talk about anything having to do with diversity or anything, frankly, that they don't like. What I have seen, I haven't seen anything that is coming from the government directly, but what we have seen is a lot of organizations already sort of self-censoring, right? You see those organizations that are taking down DEI from their websites. You see organizations that are pivoting their messaging, trying to talk more about, safety and security, anti-terrorism, things like that. And that is a decision that these organizations are going to need to make. One of the things that I keep saying, though, is, any organization that is really pivoting and trying to contort themselves into a way to get funds from this current administration under the way that they are acting and their philosophies will need to consider the long-term reputational risk that will go along with that. You may lose the trust of other funders. You may lose the trust of the communities and individuals that you're trying to serve. It is, a terrible, terrible choice either way. Do you go into hibernation and not serve your community at all? Or do you make compromises on perhaps your mission and values in order to try and get back on the wagon of this funding? The thing is, though, is that I would almost say that the reliability of the funding coming out of this administration is so incredibly low that is it really worth that reputational risk to try and do it? Or, like Shannon has been saying, is it better to try and pivot to funders that may be smaller but more in line with your organization's mission?
Thank you so much for that, Sabrina.
I'd like to comment on the DEI. So I've been doing this for more than 35 years in a lot of different war zones. We always did diversity, equity, inclusiveness. It was never called that. So you having to wipe that out of your description in your awards doesn't mean you're going to abandon that internal methodology of how you work with your beneficiaries. Just because now I have to call it gender doesn't mean that I wasn't doing it before. So, right, like there's a lot that we do that then they wanted it documented and you measure it and blah, blah, blah. You can still do DEI. You're just not mentioning it. It's not a fundamental paragraph. You can do your own internal metrics. It's a methodology that's part of your DNA, I would hope. Like do no harm is a methodology for many of you. DEI is, and you don't necessarily always fully document that. It's more that way of doing business. So I'm not advocating that you take it down from your websites. I find that to be a very difficult decision because you are who you are and what you stand for. And then at the same time, we're asking you to survive. So it's a balance that you have to make, but don't abandon the methodologies that you do because they're part of your DNA of your organization, whether you blatantly market it in your award or not, it's still there, I guess, right? Because gender-based violence many years ago was called violence against women. Now it's called gender-based violence. So I think there are ways to maintain your ethical standards and do the business that you do the way that you do, you're just not, it's not labeled, if you will, if that's helpful.
Yeah, thank you for that. Okay, so going back to I think this harkens back. Susan has a question about who defines what is goodwill. I think that she's referring to the good faith effort of the government and the presumption of that. Can you explain that standard, Sabrina?
Well, it's sort of like what one of the chief justices says about pornography. I know it when I see it, right? Something that's hard to define. Essentially, what it is in the case law is a courtesy that the courts have provided, which starts with the presumption. It starts with the assumption that the government is engaging with good faith and goodwill, but it doesn't, again, like I said, it doesn't mean that that's not something that can't be shown to be the opposite. And I do think that in this case, and so goodwill and that concept is really important when it comes to the Administrative Procedures Act determination of arbitrary and capricious. Because if you can show that, the government was making a good faith effort to do something that they believed was going to be in the best interest, but they just kind of did it in a ham-fisted way, would be a better argument for these guys, right? But if what we can show is that goodwill was never there to begin with, and again, I think we have a lot of evidence for that, it helps to strengthen the arbitrary and capricious argument, which then gets the plaintiffs over the top, winning their Administrative Procedures Act claims. So that's where that concept comes in.
Thank you so much. A bevy of questions here. Will there be guidance from DOS USAID on a streamlined closeout process?
So the US government never provides the instructions on closeout. That actually is an organizational decision. You have basically 4 major areas to close out: personnel, finances, so human resources, personnel, financial, and disposition of equipment. So all of those regulations, so human resources follow national law. For every country office, you must follow national law, because failing to follow national law will be a higher penalty, especially if you work in francophone countries. It's like whoop whoop. Number 2, so that's personnel. Disposition of equipment, the rules and regulations are very clear. Those rules and regulations are documented, and that's found in 2 CFR 200.313 or in your non-US standard provisions. So you need to follow the disposition as per the rules and the regs. If it's State Department money, remember, State Department only follows 2 CFR 200. So you would go to section 313. So there's personnel, equipment. Financial is your final financial report. And the date of that would be as soon as possible that you can. If you can wrap up that final report, your financial expenses, by the end date of your termination, that would be ideal, but maybe you need an additional 30 days. I would be reluctant to say to take the entire 120 days, because then you're just delaying your ability to get your money back. So it's really, you're empowered, your organization, follow your policies and procedures, follow the regs, and close out as per your standard way of closing out. And you can expedite that as quickly as you would like to. But they're not going to give you closeout instructions, because they wouldn't anyway in a normal award.
Yeah. Thank you. Thank you so much for that, Shannon. So related to dispositions, given the lack of AOCOs, is it viable to make a proposal and state we infer your approval if we've not heard from, heard the contrary by X date? Would that be a fair thing to submit and rely on?
Because you're seeking prior approval from somebody for something?
Just says, given the lack, is it viable to make a proposal and state, for the dispositions, for approval of timely dispositions?
So I've actually heard this as an approach, particularly because there is no one there who's responding. And so, this is an approach where, maybe it's not, Shannon, I want to hear your opinion, but maybe it's not, obviously it's not best practice. But if you are attempting to reach out and there is nobody there at the other end of the line, this is a way for you to use your best judgment on the decision that you want to make, document it, right? Look, here's my list of my thread of 3 or 4 times trying to reach out and get confirmation. Nobody was there. This was after the date that everybody was fired. I mean, you could add context to that and then simply say, the best thing for me to do in this position, using my reasonable best judgment, was to do this, and I therefore made this decision and then informed. If you are in a claims court afterwards, 2 years from now, at least you have that thread showing what your thought process was at the time, why you used your reasonable, reasonable person judgment, and this is how you came out. I can't tell you whether that would be legally, successful or not, but what I can tell you is that would be the best possible evidence that any lawyer taking up your claim would want to have. It's something that you created contemporaneously. So at the same time as all of this was going on, it was documented in the system and you moved forward. And I don't think that any judge that would be looking at a claim like that could expect anything else.
Yeah, no.
And you have the regulations on your side in section 2 CFR 200, section 308, paragraph D. The government has 30 days to respond to tell you whether or not you have approval on revisions, or they must tell you that they need more time. And since they aren't telling you anything, there's more evidence to what Sabrina is stating. So that's section 308. The whole prior approval section would also help you. Yeah. Silence isn't going to be consent, but you're documenting, you sought, you did, you're abiding by the regulations and the terms and conditions of your award. You are protecting taxpayer money by expediting this closeout, expediting these decisions as per requirement. And you also should go to 2 CFR 200.400 paragraphs A through C, where it clearly states it's the organization's responsibility to do exactly what we're saying, which is to protect taxpayer money, be cost efficient, and take charge of the responsibility to be compliant. So right. There's so much in the regs that and any memo to file that you do to justify a cost, have a statement about the regs in it. This is allowable, etc. It's not only allowable under cost principle X, it's also part of the cost principle 472 regarding termination and closeout. Thank you so much. Have a nice day.
Love that. And that is a great precursor to the next thing I'm going to say, because I see a number of requests or questions in the chat saying, can Umentum provide a template? Can Umentum provide guidance? Can Umentum advocate? Yes, yes, yes. We're here with you to try to sense make. And one of the things we're doing is offering an extremely low cost course right now, $179 for members, and $199 for non-members. So, it's a great deal. It's a two-day course, Shannon. And Shannon,
2 webinar course, yeah.
Of course, Shannon's the instructor, and we'll walk you through kind of all your rights, your responsibilities, the things you need to do to kind of in response to termination and make your best case to get reimbursed, etc. So I will plug that, and I know Jenna will put information about that webinar in or those 2 webinars in the chat coming up. We do have a legal question here, and I just need to make the plug here. None of this is legal advice. Please don't take it as such. Always consult with your own attorney, in-house or otherwise, for legal advice before you make any decisions. Everything here is for informational purposes only. So having said that, Sabrina, I guess, the signing or Shannon, does the signing of the DS 1909 grant modification forms that are being used at least by PRM for termination take away our right to an appeal? What are the implications of signing or refusing to do this?
Shannon.
I don't
know the answer to this one.
Oh, okay. So if you go to, if you you have 30 days to make an appeal to that decision. If you acknowledge the letter stating you understand that you're under termination and you know that you want to appeal it, you say you acknowledge the letter and we will be appealing and submitting a case for appeal within the next 30 days. That would be my advice. And to underscore what Cynthia said, I'm not a lawyer, I'm not your lawyer, but the regulations are clear. You have 30 days to submit. And for the State Department, you need to go to their standard terms and conditions, which means you need to go to the 2024 archived site of standard terms and conditions of the State Department. Luckily, they have that up. I was so happy. I'm not happy they don't have AID's website up to get all the regs. But Humentum in the course, we have the most recent standard provisions for US and non-US, because those of us that teach that all the time downloaded that. All the 2 CFR 200s, 700s, and 600s, they're all online because those are also applicable domestically. But the appeal process is you have to submit something to the State Department within 30 days, whether it's USAID funding or State Department funding.
I would go back again and say, though, I mean, that was a very specific question, and I'm glad that Shannon had the answer to that specific form. But what I would say, because this question came up a little bit earlier about the DEI forms and if the government is requesting anything, if there's anything that is being requested that is, you know, a little bit strange or circumspect, you know, again, this is where you need to go back and make that decision. Do you ignore? Do you acknowledge but not necessarily respond, or do you comply? And depending on what it is and what your risk comfort level and what your leadership and your trustees, you know, and your own legal counsel are telling you, that will determine what you need to do. At this point, though, with all of the chaos and how we kind of started this whole conversation about, you know, it is just chaos. I can't think of a better word. There is nothing wrong with organizations erring on the side of we acknowledge, but we, you know, are going to pause right now, because exactly what Shannon was saying, you know, I mean, you can't even find the regulations on the website anymore, right? You have these rights, you have these 30-day windows, or you have the right to not respond, or whatever it is, but it's very difficult to find that particular language right now. And especially with all of the temporary restraining orders, preliminary injunctions, and all of the challenges that are flying around and will continue to fly around, there is nothing wrong with you acknowledging and pausing. As long as what Shannon and I were just saying is you're documenting why you're doing it. Again, I have a feeling that the arbitrary and capriciousness of many of these decisions is going to be found valid, and you will be in an okay position, again, if you acknowledge, but then you document why